So I'd like to thank everybody for joining us tonight. I hope everyone's having a pleasant evening so far. This is going to be an hour-long presentation. If you are in Arizona, there will be a survey at the end for foster care continuing education. For everybody who's not in the state of Arizona, thank you anyway. I do appreciate you being here. Um, and so, yeah, we'll be about an hour long. Please feel free. There is a question and answer button that is different than the chat. So if you have a question, please raise that in the question and answer section. Just a couple of limits on that. Please don't put in anything case specific or any identifying information. This is an informational session. This is not somewhere to get, we're not giving out any kind of attorney or legal analysis or anything like that. There will be at the end a link for our intake form. So if anything comes up that you think is going wrong in your case, please feel free at the end to go to our intake, fill that out. And that way we can use those as our metrics and then we may be able to give you some actual one-on-one legal information. So with that out of the way, you came here to hear that kids have constitutional rights too. And we're the Center for the Rights of Abused Children. So it's right in our name that we definitely think kids do have constitutional rights. We believe that every child deserves a safe and loving home, whatever the circumstances of their birth were. Every child should be safe and loved. So a little bit about the center. We are a 501c3. We are dedicated to advancing, preserving, and defending the constitutional rights of children who are in or around foster care. We do this through several ways. So we have a policy side that was worked in Arizona for a number of years and works in other states and also federally to push policies and laws that respect children's rights. Then we have a legal side, which itself has two sides. We have an impact litigation side, which is kind of your traditional NAACP model of going to different states where there are various and sundry problems affecting children in foster care and to find clients and litigate cases up to get reported opinions respecting children's rights. And then there's what I do, which is our children's law clinic, which is more based in Arizona, and kind of the more run-of-the-mill cases. Not everything has to be, a big Supreme Court victory for us. We take all sorts of things in our clinic for Arizona. So then a little bit about me. My name is Tom Jose. I am the director of the Children's Law Clinic here at the Center for the Rights of Abused Children. I am a licensed attorney. I have, in one way or another, seen most of the facets and represented all sides in dependency and severance proceedings. I've worked as a clerk for the judges deciding these cases. I've represented the Department of Child Safety in Arizona. I've represented bio parents, foster parents, children both in and out of foster care, private severances, DCS-led severances, dependencies, guardianships, and everything from even just the initial investigation step through ALJ hearings if necessary, to the Superior Court, Court of Appeals, and even up to several state Supreme Courts. So I have throughout the years had a chance to see most of the facets and sides, but this is such a large area. I'm learning more every day. Just this morning, I was on a call with a gentleman from DCS who does the adoption subsidies and was learning a lot about that. Because most of my experience is on the dependency and severance side and not, adoptions and stuff like that. So there are always going to be facets of this area of law that are going to be new to me because it is so far reaching and just all over the country, obviously. So that's a little bit of background of the center and of me and why you might want to listen to me. So I always like to start with quotes about centering what it is we're doing and what we're talking about. So this is from the U.S. Supreme Court saying constitutional rights do not mature and come into being magically only when one attains the state-defined age of majority. Minors, as well as adults, are protected by the Constitution and possess constitutional rights. And I like to think of this as saying kids don't just spring out like Athena from the mind of Zeus as fully formed adults. They come into the world as babies, but they are nonetheless human beings endowed by their creator with certain inalienable rights. And the tricky part, and I think to me the interesting part, is what are those rights? How do they exist? And when the child cannot defend them themselves, who is defending them? How are they defending them? And what do they look like in practice? Because I think most people can agree, yeah, human beings are born with rights. Um, the hard part and the part that people disagree a lot about is how does that practically manifest? And that's what we're going to talk about tonight. So this is what I think will shape tonight's conversation of these are things that exist. And most of what we're going to be talking about tonight are ones that the Supreme Court and or federal courts have recognized already. Um, but Supreme Court gets it wrong sometimes. So we'll talk about that too. So a little bit of an overview of what we're going to be talking about, our roadmap for this evening. Um, I have a little bar here. There we go. So kids have a right to be safe while they're in state custody. They have a right to family integrity, and that has a couple different facets to it. And a right to emotional security is a huge one, especially for foster parents. The right to permanency in a timely manner, and the right to an adequate education. Each of these is a big one that itself take up an entire hour. So we're going to kind of blast through these at a 10,000 foot view tonight. So the right to be safe while in state custody, that's going to include being protected, obviously, from physical, sexual, and emotional abuse, adequate shelter, food, medical care, clothing. These are pretty basic things. If the state is taking kids into custody because the parents have failed to give their children that, and then the state fails to give them that, well, we're not really helping kids at that point. So these are really kind of the basic minimums that we have to talk about. Um, and obviously, the state does not always meet that goal. I mean, we've all seen where kids come into care. We had, oh goodness, maybe 7, 8 years ago, the foster mom down in Maricopa, who was forcing her foster kids to do YouTube videos, and meanwhile, was beating and abusing them. That was a failure of the system. Is that those children had a right to be free from that kind of abuse once they came into care. Um, Adequate shelter, again, if a child is not getting adequate shelter while in state custody, that's violating their rights. And that, in my mind, I don't know if we have as many cases about this, but in my mind also includes not keeping kids indefinitely in welcome centers or in offices or in hotels. Um, they need a home to go to. Minimally nourishing food, obviously, even when in care, even when in foster care or in a group home, kids are not entitled to McDonald's every meal, although they may be asking for it. Foster parents as well as bios are fully capable of saying we have McDonald's at home. So it just has to be nourishing. It has to be good food, nothing moldy or crazy or anything like that. Medical care. This is one that oftentimes, at least in Arizona, state gets pretty well. They do have good health insurance for kids in foster care. Whether that be Altex, CMDP, which is now Mercy Care, or other ones, they usually do a pretty good job of getting kids Medicaid. And this comes from the substantive due process, uh, which is the due process clause of the 14th Amendment, which the Supreme Court has held has substantive rights. So this is considered a substantive due process right. Then we have a couple examples here. Not really anything people other than lawyers need to know, but we want to give them to you in case anybody wants to read up on their own. All of these, all you do is take these like 774 F third 45, Google that, and you should be able to find it for free. I think it's what, Purdue University? One of the law schools has a pretty good comprehensive legal database. So especially reported cases from federal circuits, those are all going to be easy to find for free. So just pop it into Google and you'll find them if you want to read the whole thing yourself. So when we're looking at this, it is the right to be safe while in state custody. It is not a general global right for children to be safe, unfortunately. Um, and this was from a case called DeShaney v. Winnebago County, where the county did get several claims that a child was not safe, chose not to act, and the child ended up, I believe, did not die, but was severely injured by one of her parents. And so the other parent on the child's behalf went to sue the county for failing to, keep the child safe. It was like a non-custodial parent was suing the county for what the custodial parent had done to the child. And the Supreme Court said no, the state chose not to act and therefore did not, there was no liability there on behalf of the state. So, and this is something that we still see to this day, unfortunately. This was a big one just recently here in Arizona. Was the state had received, depending on who you ask, somewhere between 3 and 40 hotline calls about a child. And they, some of them they kind of investigated, some of them they pushed under the rug, some of them they just didn't do anything. And unfortunately, the girl ended up dying. But because the state chose not to act, it is not going to have any liability towards her or her next of kin. This is something that we're working on in the center in our impact litigation. This is a precedent we do want to overturn. We do believe that the state has an affirmative duty to keep all children safe. That was certainly, if you look into it, at least in my opinion, certainly what the drafters of the 14th Amendment intended by it was that the state was supposed to be keeping, the freed slaves safe from like Klansmen and other private operators trying to murder them. So it's gotten distorted by the Supreme Court over time to the point where it is now. But we do think that the 14th Amendment was intended and really functions better if the state has an affirmative duty to protect people, especially children, who live within their boundaries. So, Logan, do we have any questions on the first one?
We don't have any questions on the content, but someone is wondering if we'll be sending out the PowerPoint.
Yeah, absolutely. Anybody who wants it, I think we have a contact at the end. Just shoot us an email at the end. If not, you can send it to our emails are pretty simple. So it's, thecenterforchildren.org. So I'm Tom at thecenterforchildren.org, or there's also hello, or intake at thecenterforchildren.org. So just shoot us an email if we don't have that contact information at the end. I'll let you know again and just, send us an email and I can shoot this over to you. So next is the right to family integrity. So the right to remain with their family, unless, of course, family is unsafe, the right to reunify with safe parents, the right to maintain safe relationships with their sibling set while in foster care, and the right to stable family-like relationships with both kinship and their foster families, certainly after termination of parental rights, should that become necessary. So there are several circuits who explicitly recognize children's right to know and be raised by their parent. This is, I know a lot of people talk about the parents' rights to raise their children. That's been recognized by the Supreme Court, as I think we have in a couple slides here. But not all courts have recognized the reciprocal, that the child has a right to that as well. That I think has caused some confusion in what the nature of the rights are. And when you hear a lot of stuff about parents' rights, I think that comes from more of a confused understanding of what's really going on. Is a relational right, by its nature, needs two parties, right? So it's not like your property rights is one party in a piece of property, but between two different people, a relational right, I think, has to naturally exist in both. So we've got several states that have recognized this, that the child also has a right to their biological parents. And again, we've got a couple citations here if you'd like them. And these are considered fundamental rights. So certainly, I think we're coming up on Santosky next, right? Yeah. So this is, the big banner case for parents' rights is the fundamental liberty interest of natural parents in the care, custody, and management of the child does not evaporate simply because they're not proper parents. And that is where we get it. As a fundamental right is considered one kind of even more basic and primordial than the Constitution itself, and that um, really that is kind of the basic, foundation of how society works is the familial unit, and of course, parents do have fundamental rights. Um, and so, like I was saying earlier, is that not everybody has recognized this reciprocal right of the child. The Supreme Court has never come close to it. However, in a dissent from 2000 in Troxel v. Granville that you see, um, Justice Stevens says, I mean, yeah, come on, like it's a two-way street here. And that's something that you see children's attorneys, especially when a case is acceptable for unification and the parents are fit. That's something that children's attorneys will be asserting as well, is that they're going to say, hey, this child has a right to go back to his or her fit parents. Um, so it is something that's definitely recognized for parents, and it is something that more courts are coming on board. And I do think if the U.S. Supreme Court ever got a case where it was squarely presented to them, I do think the U.S. Supreme Court would recognize that as well. I'm hard pressed to see a strong argument the other way. And even in Santosky, we see the recognition that not only do the parents have a right to not have their rights erroneously terminated, so too does the child have a right to not have. See, and it gets weird if you're just thinking of through a parents' rights lens, is that the child has a right not to have their parents' rights terminated against them. Because that is that reciprocal relationship. So you can even see where it is starting, even in the black letter case law. Um, Children's right to sibling relationships, we believe that should be a constitutional right. It is not one that has been found by a whole lot of courts yet, and it is something that, as far as what I consider children's rights, is the one that is most uh, trampled upon. Um, but it is part of their right to family integrity. Is not only do you have a right to a relationship with your parents, you also have a right to a relationship with their other children. Um, and that's something that is not recognized a lot of places. Um, and even when it is, you'll see here an example from Arizona where we practice, is that they have to make reasonable efforts to keep children together. And admittedly, in practice, that does become hard in a lot of cases. Say you have sibling groups that are five, six, seven, eight kids that are ranging from 1 year to 17 years, and all have different special needs that need to be accommodated. It's not always possible. But even when it's not possible, reasonable efforts should be made that they have contact, that they have visitation, that they can um, maintain as normal of a sibling relationship as possible within, the hand they've been dealt. Um, and I think that's very important for the emotional stability of children. Is a lot of times you'll see their brothers and sisters are really all they got. If they have unfit parents or if their parents are deceased, and they fall into the system, a lot of times they got their brothers and sisters, and if you split that up, you're really taking away from them the last shred of family that they've had in their lives. And yeah, it is possible to rebuild that, but it's never the same. So sibling contact is a very important right to family integrity that children have. I mean, especially as just keeping what's left of a family integrated together. And that's another thing that we're working on, both through the clinic and in our impact litigation, is getting these rights recognized by courts, that children do have a right to sibling visitation. So next is the right to emotional security. Um, so this includes therapeutic and mental health services, visitation, appropriate medications, or pushback against inappropriate medications, whichever way you see it. I think we see more of the latter than the former, but and continually assessing if it is safe for the child to return. So we kind of start this of a child in foster care. Well, oh, we start this really before a child comes into foster care, right? And that when we're assessing whether removal is appropriate, we have to start from a place that removal is going to have a huge negative impact on the child. Um, Regardless of whatever else might be achieved as far as their safety goes, we do have to know and recognize and acknowledge that being ripped out of your home is going to be traumatizing. Um, and this is something that happens even, newborns from the hospital. There is a connection when they form in their mother's womb with the mother. So even when we're talking about a baby being removed from the hospital, that is a trauma that is being inflicted upon this child. And yes, it may be for their safety and to prevent other traumas from happening. But one thing we need to stop and think about this child's rights is this child does have a right not to be traumatized or to be as little traumatized as we can manage. So that's going to be the first thing is that when we're looking at whether removal is even appropriate in the first place, we need to understand that removal by itself has a huge traumatic impact on a child and weigh that appropriately against what other safety concerns, um, safety issues, or further traumas or other traumas might be inflicted upon the child if he or she is not removed from their parents' care. Um, and that's a balancing game that has to be weighed. And usually that's going to be something, well, it's going to have to be a pretty significant safety concern, right? We don't want to be willy-nilly taking kids from their parents' care and then a month later going, I guess it was okay. You can go on back. Because that's going to inflict just a lifetime of instability in that child's just their ability to be at home and feel safe in their own home, right? If at any time they feel that the state can come in and just pull you out when you didn't even do anything, right? From the child's point of view, they didn't do anything wrong and they're being pulled out. So that's I think the starting point, and then from there we also have to think of what therapies does this child need. I think we talk a lot about um, with foster kids and their services. We talk a lot about occupational therapies and speech therapies and things like that. But it is important to recognize that they also need age appropriate cognitive therapy a lot of times. It is something that I think falls to the wayside in too many kids. But it is very important that they get the mental health services and therapies that they need. And that's something that's going to be a continuing evaluation throughout the case, especially as a child grows older, and um, especially for the older kids. I mean, even going back to removal for older kids is also very important to understand that this has to be a very significant safety threat to remove this kid. You take an 8-year-old kid who has lived with his mom his entire life, and now you're saying we have to take you out and put you in a house with strangers. I mean, there's got to be something pretty significant that is going to require that. It's not something that we can be flippant about or just say, oh, well, she's on drugs, so therefore, we have to connect things to the child's unsafety. And just to overcome what that trauma is going to be. And then once we do, I mean, because obviously I'm not saying it's never appropriate to remove an older child, but we also have to make sure it's for, necessary reasons. And then once we take that step, we also have to be very vigilant about making sure that they receive the mental health care services so that they can not only, I mean, at the beginning, contextualize and understand what their feelings are and where they're coming from. Um, and to first understand them and eventually get to a point where they can start to heal from that. And I think, especially for older kids, that's especially important if we are on a reunification track of they need the room to feel their emotions about being pulled out of their parents' home, their emotion, conflicting emotions of how they feel about the way their parents treated them, and their ongoing and forward conflict of what is it going to look like when they go back to their parents. And there's a lot, it's common to say big emotions in a little person, but it's very true, is that this is something that is going to be shaping essentially their entire lives. So having those mental health services in place for the entirety of a dependency is going to be critical to a child's ability to, you know, not only form familial bonds now, but form friendships, form um, as they grow older into adulthood, enter into romantic relationships, and form families of their own. Those are all going to be critical things that are happening right as soon as they're removed from their parents' care. So they have a right to that, and they have a right to feel emotionally secure where they are, and to have services in place for their mental health and their emotional security so that they can feel secure both now and in the future. And it's a very hard thing to do because they were somewhere and got ripped out, and the natural tendency is to feel emotionally insecure after that. Appropriate medications or pushback against inappropriate medications. This is something um, I think we see a lot with the pushback against inappropriate medications with kids who are in group homes, to where in not the best environment or having a staff that is not properly trained, you can see kids getting medicated for things that are either normal kid behavior or normal behavior under the circumstances. Um, we should not expect that a child who has been abused, neglected, abandoned, had the trauma, had those traumas, trauma being removed from their home and going through a court case that they don't understand. We should expect them to have, you know, some behaviors that we don't see in other children who are, still in their nuclear bio families, right? Um, and that's not necessarily a mental illness that requires medication. I think we see a lot of these inappropriate medications because we are not getting the mental health services in place that they need, is that they don't have a place to explore and expound upon their emotional turbulence in a healthy and safe manner. And so then you see them, doing things that are inappropriate, things that are bad or naughty or whatever, to running away, drugs, running around with older crowds, what have you. These are, I think, very oftentimes responses to the traumas and are not necessarily things that need to be medicated. Um, on the flip side of making sure that they get appropriate medications, there is a lot of times with bio parents, there can be a power struggle dynamic where sometimes the bio parents feel that because the state has removed the kids, they don't have the power over their children that they used to, and obviously they don't. And so sometimes bio parents will try and turn this power struggle into things like, um, they're not really emotional security, like I don't want my kids getting the MMR vaccine, or I don't want my kids seeing a psychotherapist, or I don't want my kids doing this or that. And possibly the child does need some sort of psychotropic medication, and you could see sometimes the bio parents as a power struggle trying to reach out and saying no, no, no. And it is a legal gray area, as far as dependent children go, where exactly medical care rests, as a legal thing. So that's where I think you see that it is, and we have to try and again find a right middle ground of making sure that people who care and are invested in the child's best interests are coming together to try and make these decisions together as much as possible. I know it's not always, and maybe it's often not, but to the extent that we can, I think we need to all be coming together with medical professionals and trying to agree on a course of action so that a child is neither under medicated nor over medicated, and continually assessing if it's safe for the child to return. Right, is at base the point of foster care is to get the kids out of an unsafe situation and give the parents the room that they need to ameliorate their circumstances and get to a point where they are now fit parents. And part of the child feeling emotionally stable and secure with their parents is, if they can see, oh, my parents are okay now, so I can go back. Whereas if they see, oh, my parents are okay, but I'm still not allowed to go back for another 6 months or a year or something like that while the parents are jumping through unreasonable hoops. Um, that's going to be detrimental to the child's emotional security when they eventually do go back, right? They're still going to be on very heightened alert that, oh, the state's not always reasonable in the way it conducts its actions, and so maybe they'll just come back and tear me out again because they just don't like my parents. um and that kind of, I think, goes to a child's sense of fairness as well. As I think a lot of kids in these situations can understand when their parents are unsafe, um but also if they see that their parents have become safe and they're not allowed to go home, I think that really plays on their sense of fairness. Um, all right. Now, what might seem at first kind of the flip side to that of what I was just saying is the right to permanency in a timely manner, um, which can include severance and adoption. Um, but most fundamentally, permanency in a timely manner is usually going to mean reunification as the permanent plan. So right to permanency is going to include the right to be heard, the right to counsel, which is a statutory right, not a constitutional right, um, if necessary, to find a family and be adopted, and to timely court proceedings. So the right to be heard, is an interesting one. It's I think we give a lot of lip service to it. Not at the center. I mean, we in the legal profession and in the courts give it a lot of lip service, but when the rubber meets the road, it goes by the wayside, I think, pretty quickly. So, at least in Arizona, one of our procedural rules is that the child's attorney, when announcing, is supposed to say whether the children are there, and if the children are not at the hearing, why the children are not there. And if the child's attorney fails to do that, the judge is supposed to ask, hey, will the children be attending? And if not, why not? And we almost never see that. That's been a rule on the books for, goodness, 4 years now, I think. Um, and I think the only times I've seen it done is when I've done it myself. It's very rare to see. So we put on the books all this dead letter about, oh, children have a right to be heard. They are parties to this, so they need to be able to attend hearings and to be heard at these hearings. And everybody gives, I think, a lot of lip service to it, but at the end of the day, we very rarely see children at hearings. Um, and they still will get to right to counsel when they have counsel. They are heard through their lawyers. Um, but I think I think the legal community in America needs to have a bigger push to actually treat these children as full parties and ensure that when they want to be heard, they are heard. Um, so the right to counsel is not currently recognized as a constitutional right. It has never come up to the United States Supreme Court before, as far as I know. The issue of whether a parent has a right to counsel has come up to the U.S. Supreme Court, and the court essentially held no, but it would be nice. Um, and the reason for that, and why I think parents don't have a constitutional right but children do, was a lot of that analysis was based on, it's not a Sixth Amendment right to counsel, right? So when you're arrested, you have a Sixth Amendment right to counsel. It doesn't fall under that because you are not being physically restrained by the government as a parent. So that analysis doesn't adhere for parents when the children are removed. However, I think the center believe that when a child is removed from their parents, that is the government restricting their freedom to move. They are not free to go where with their parents. And so changes that analysis enough that I believe there is a constitutional right for children in dependency proceedings. However, like I said, that has not been recognized by any federal court, to the best of my knowledge. In about 35 states, children do have a statutory right to counsel. These take various forms. Um, so in Arizona, right now, children have a right to an attorney by statute, and that's a client-directed attorney. And we're going to distinguish that from a guardian ad litem. So a client-directed attorney is the same as you or I would go and hire an attorney and say, I want to draft a contract to sell my car, or I want to get a divorce, or um, this guy broke the contract for the sale of the car and I want to sue him now. And you go and you tell the attorney, here's what I want to do. And the attorney says, great, okay, here's a course of action I think is going to be the best one to get you there. And we go, okay, cool. And the attorney goes off and does, his or her job, but you're telling him or her what to do, right? So in Arizona, that's the way the model works from birth through 18. And I think you're probably thinking right now, well, what about the birth side of kids who are nonverbal, kids who are not yet at a point where they can uh, cognize or articulate what they want or even what's going on. And for that, we have a substituted judgment rule. Um, and a lot of our rules on this come from what were already existing ethical rules for when attorneys were dealing with people with diminished capacity, adults with diminished capacity. And fundamentally, that's what we're saying is children just have a diminished capacity compared to adults. And so what substituted judgment is the attorney, first of all, has to determine that the child does have a diminished capacity. If you're representing a 15-year-old, they can understand what's going on very well and say, this is what I want to happen. And they're fully capable and able to direct representation. But when the child does have diminished capacity, the attorney has to stand in the shoes of the child and say, okay, what do I think this child wants in this situation? Um, it is tricky. It is certainly in child protection is definitely newer, and attorneys are having a lot of issues with it. And we are getting a lot more scholarship on it. I'm actually reviewing a paper right now from someone trying to get published talking about different ways that we could handle the issues of um, the hardest parts are not even like the real young babies. It's those kind of periverbal, like toddler to like 5, 6, um, when they can say things, and it becomes real dicey of being able to determine not only what their capacities are, but also what they would want. And when they are expressing something, whether that's really what they want or if they're just goofing off, right? Because if a kid says, well, what I really want you to tell the court is I want to go live with a pink elephant on the moon. Um, I'll tell you right now, I'm not walking into court telling a judge that. Your Honor, my client really wants to go live with a pink elephant on the moon. So if you could have the department take care of that, we would greatly appreciate it, right? Um, and it is hard. So that's an emerging, I would say, one of the emerging fields or subfields within child protection, kind of the cutting edge, both not only on the legal side, but also um, on neuroscience and psychology as well. Um, and so, sorry, so I haven't completed this yet. There's also guardians ad litem. So that could take a couple different forms as well. Some places, I would say in a lot of places, including Arizona, GALs are attorneys. They're just what are considered best interest attorneys. So technically, a best interest attorney works for the court, not for the child, and is not really concerned about what the child wants. And it's just about assessing, just as objectively as possible, what is going to be in this child's best interest. So the kid could be screaming up and down, I want my mommy, I want my mommy, I want to go home. Um, but if mommy still has whatever issue she has, they can tell the court no. We're advocating that the child remain in placement, right? Um, So, and then there are about 15. So there's various different forms of that. So Arizona is probably one of the more absolutist on having client-directed counsel, or I guess strictest. Um, there are other models where a kid will get, say, a GAL or a best interest attorney until a certain age, could be 8, 10, 12, 14, something like that. And then they'll get a client-directed attorney. And then there are several states that just have the best interest model, and several states where kids just get nothing. Um, because since there has never been a reported Supreme Court case saying that kids do have a right to counsel, and what we have on the books is that parents do not have a right to counsel, a lot of people have somewhat reasonably taken the stance that, okay, nobody has a right to counsel in these proceedings. It's just going to be, we're just going to throw you at the mercy of the state in a court of law. Um, I don't feel comfortable with that as a lawyer. I don't think that's how that works. And I think, especially children, because their freedom has been confined by the state, I do believe they have a constitutional right to a client directed attorney. Um, Permanency and timely manner to find a family and be adopted if severance is going to end up being um, the right path. They do have a right to be adopted. We certainly, I mean, we certainly see kids who end up as legal orphans for extended periods of time, and we don't like to see that. That's not what we're setting out for. So children do have a right to find a family, um, and that's just again permanency in a stable home, a stable and loving home. Children have a right to that, and it's one that's not always respected, and that's unfortunate. And I wish we could do more to change that. It is both legally and practically, there are a lot of issues between here and there, but it is an important one. Um, Fortunately, the next one, right to timely court proceedings, we do see more regularly. I believe under ASFA, it's every 6 months you have to have a report hearing. In Arizona, we generally set them at every 3 months, which is even better. Um, and then, after the first permanency hearing in the case, every report and review hearing after that in Arizona, at least, becomes also a permanency hearing. So the question, at least in Arizona, of a child's permanency, once we get far enough into the case, that becomes something that's kind of up for debate every 3 months. Um, and I'm for that. Um, getting to children to permanency without undue delay, I don't think we do as good a job on that. I believe studies have shown that the average child spends 1 to 2 years in foster care. Um, that probably is within ASFA with the 1522 rule, but we also see a lot of cases where kids are going 2, 3, 4, 5 years time and care. And we are failing them. That is too long to live without knowing where your permanent home is going to be. 5 years is too long. Um, and so we see this for a couple of reasons. A lot of it is usually intractable incompetence on behalf of the state. Things like they want to start going they finally realize or come to the conclusion that, severance is going to be necessary. And then they realize, oh, well, we never actually established paternity on dad. So then that's going to push it back another, 3 to 6 months while they're, um, either they're trying to serve dad and then eventually go to publication on a John Doe, something like that. Those are some of the biggest hurdles to undue delay that we see in permanency that really I is just inexcusable in my mind. It literally is just the state trampling on children's rights without any real good reason, other than some attorney was lazy and didn't feel like doing the job. And in my mind, that's unacceptable. Um, you're coming on to
We have two questions.
yeah,
First, is there a minimum age requirement for the child to be present in court? And they didn't mention a state, so.
not to my knowledge, no. There definitely is not one in Arizona. Babies are allowed. Um, and I've talked to, I mean, I think I've represented younger kids, like 6, 7, Sorry, that was not intentional. Um, 6 or 7 years old, um, who either did attend or didn't attend, and then said, Your Honor, my client's not here today. He's in school, and he would rather be there. So, um, I mean, think of it this way: aren't kids always at the adoptions? I mean, if we think of adoptions like, yeah, that's going to court and everything, right? And kids are almost always at their adoptions, whether it's an infant, a toddler, preschool, whatever. Um, to me, it seems like whether they're going to court for that, that's a court proceeding regarding them, and so is dependency. So I can't say for any of the other 49 with any certainty, um, but I have never heard of there being a minimum, uh, and I know there's not one in Arizona.
Great. And then before I give you the next one, I see someone raising their hand. If you could try and type your question, then I can read it out to Tom. And so while we're working on that, the second question is this is all being recorded. Are you able to email that out as well if individuals reach out to you?
The recording,
Yes.
assuming somebody else does the technology side, yes. Our plan for this is to post it on our website. Um, but I am not the tech guy, so shoot us an email and we'll figure it out one way or another.
Perfect. Okay, I'll let you know if more questions pop up.
Okay. So yeah, going back to the right to be heard, right due process is the right to be heard in a timely or in a appropriate time in an appropriate manner. Or sorry, meaningful time, meaningful manner. And so children should be able to show up and be heard. Um, oh, and here's the one. This was the one giving um criminal defendants a right to an attorney in Ray Galt. And like we were talking about, um, oh, and this is the delinquency. Sorry, this is for children getting delinquent children. Um, and we think that, it's my opinion is that it's very similar when a child is removed from their parents to when they are put in juvie. Um, and Lassiter is that, again, maybe deprived of physical liberty. Lassiter was the one that said parents don't necessarily have a constitutional right to counsel. Oh, I just kind of went all over this just off on my own. So, like I said, email us if you want to read all this. This is just mostly going to be what was should have been up while I was talking about all this stuff. All right, so the right to an education. In this sense, foster children are no different than any other child. We have public schools for a reason. We as a society have determined that it is best for our society if children are educated. And this applies no less to children who are in foster care. Every state constitution has language regarding education, some better, some worse. Um, when the child is removed, when the state removes a child, takes up positive action, they have a requirement to make sure that the child gets educated, right? It's before a child is removed, you can, homeschool, charter, private school, whatever. But once the state removes a child, then that burden is on the state to provide it. And I have not seen a lot of kids who are doing homeschooled in foster care. I don't think I've ever seen it actually. Um, but at least in Arizona and a lot of other states, especially in the West, um, there's got to be a public school system, board of education, all that good stuff. Um, and also in Arizona, children have a statutory right to receive an education that fits a child's aged individual needs and a right to be in the least restrictive school available. I don't think many people find this controversial. Again, the devil is really in the details. So educational stability is one of the biggest ones for foster children. It's huge. Then behind that is special education, again, school discipline, and then kind of the particulars of getting older kids to transition into adulthood. I don't know if you have individual. No, okay, we don't. So educational stability. This is huge because, again, like I was saying about siblings earlier, a lot of times a kid's school and their friends at school are their only last remaining link to normalcy once they get removed from their parents' home. And so, oh, too often a child will be placed in foster care halfway around the city, halfway around the state, and then just, oh, you're going to go to a new school now. You're not going to see any of your friends ever again. Sorry. And that's not appropriate. That's not okay. We in Arizona a couple of years ago passed a law that requires DCS and a child's old school and proposed new school to have a best interest determination meeting when the child is first removed and anytime that child is moved to another placement to determine whether it's in the child's best interest to go to a new school or not. So they sit down with the old school, the new school, and DCS, and they all, in theory, hammer out what's going to be the best for this child. Should he stay here? And it's huge because you see so many foster kids popping in and out in the middle of school years, right? Is that placement decisions are made about them or removals are made about them, removal decisions are made about them in the middle of a school year, in the middle of a semester, and then they're just unceremoniously popped out. And a lot of them have been in school their entire lives, but are so deficient on credits because they had, oh, half a semester of that, quarter semester of that, and they're not getting full credits. Other times you see when kids aren't being enrolled in schools timely, whether that's from a paperwork issue or intransigence of some party of kids just sitting around when they should be in school and just doing nothing, 7, 8, 9, 10 year olds. So educational stability is huge, and children definitely have a right to it because that's going to also feed in to their emotional stability and a lot of other things. Special education and related services, a lot of kids who are in foster care have IEPs and 504s. Those require a high amount of advocacy. Both on the familial side and sometimes from education advocates or even eventually lawyers. But all children in foster care are entitled to be evaluated for IEPs and 504s. They are entitled to all of that just as any other children are. Um, Something we see, especially in Arizona, that we have, not to get political, a lesser funded educational system than other states have. We do see a lot of pushback from schools and districts on implementing IEPs and 504s. It's one of the big education related problems that we have is just getting schools to do IEPs and 504s and make sure they're doing them right. School discipline, this goes back to what I was saying earlier about the medication of you might have these behaviors and outbursts that for a child who is, lived with their nuclear biofamily since birth would not be appropriate and is not appropriate in school environment. But because of the traumas that they've gone through, if they're not getting things addressed appropriately, even sometimes when they are, kids getting disciplined for things that really require more of a therapeutic or mental health angle. And preparing older youth for transition into adulthood, this is going to vary widely state to state of what programs they put into place. It's also going to be very widely in your foster placement. If you have a traditional, um, two-parent household as a foster parent who is able to get you into good schools and all that stuff, you're going to have an easier time transitioning into adulthood and even doing things. Um, I've had clients who are already taking community college classes while they were in high school and stuff like that to transition them out. Versus if you're just thrown into a lackluster group home, it's less likely you're going to be getting those things, but you should. They both have the same right to them. And I mean, that's just basic allowing humans to flourish. And that these kids are being held back and that they have a right to flourish. They have a right to transition into adulthood and to get into an educational program or a training program, vocational training or college or workforce, whatever have you. And this touched on some other things like, getting birth certificates and things like that so that they can get into them explaining what the differences and things are. They have a right to these. It's very messy and muddy and complicated right now. Um, these are the questions for the continuing education quiz. Um, man, that's a hard one. I don't know. It might be F. Family integrity includes the right to maintain safe. It's probably true. I don't know. I don't know though. That also might be true. May not. Probably. So yeah, here's our contact, Tom at the centerforchildren.org, or to go to our intake form for the law clinic, the Children's Law Clinic, scan a QR code. And I don't know if I mentioned this before. Our Children's Law Clinic is 100% pro bono. We never charge for anything. We don't charge for legal time, paralegal time, filing fees. We don't charge. Um, and that's mostly because as an attorney, I don't like to bill. I don't like to, that's a lot of paperwork that I don't want to have to deal with. So it's just a lot easier if we just don't charge, right? Okay, that's all I have. We're at 6:59.
Um, we
Uh,
have a great question to end it on if you have 30
wonderful.
seconds.
Oh, I have more than 30 seconds. If you want to keep, you're free to go. I'll be here for a while. I say this every time I give one of these evening ones. The rest of my evening's open. Like, all I'm gonna go do is drink some beer and play Xbox. So if you have questions, keep them coming in. It'll keep me on the straight and narrow a little longer. So yeah, what do we got?
Great. So it's Jeremy's asking, what should we do if constitutional rights of a child are not being upheld in our state? And then he says Idaho, just for example.
Um, Go to our intake form first of all, and let's see if that's something that we can do on our impact litigation side. Um, it is Idaho, if I remember correctly, is a hybrid model where kids are getting GALs till I think 12, and then don't quote me on that though, I might be wrong. But the first place to start is if the child has an attorney or GAL, you got to start with them, right? If the state is violating their rights, the first place to start is going to be with the child's attorney in their dependency case. If that does not work out, it is something you could consult an outside attorney about, possibly suing the state. Um, Section 1983 lawsuits, those kind of lawyers would be what you'd want to look at. Um, a lot of times those are not viable, especially when the dependency is open. Uh, and there's a lot of questions about who would be, the next friend to sue on behalf of a child, questions of guardianship, and who, you know, um, is going to be capable of bringing that suit for the child. Um, but those are all going to be kind of particular to each case, each state, and each child. So it would be something you want to contact, yeah, first the child's attorney, if that's not possible. Um, Somebody who works in, they'll call it 1983 lawsuits, which is essentially just the federal statute that allows you to sue the government for the violation of your civil rights. So try and do, check with them to see if there is a case available, if it would work. And otherwise, if you are in a particular case in a particular state, um, yeah, shoot us an intake.